Hi there, I'm Christine, and this is the Canadian Constitution Foundation's Freedom Update. Today, I want to tell you about a recent decision from the Alberta Court of Appeal involving the Trudeau government's No More Pipelines law. The law is formally known as the Impact Assessment Act, and it was just deemed unconstitutional by the Alberta Court of Appeal. Let me tell you why. If you're new here, welcome. My name is Christine Van Gyn, and I'm the litigation director for the Canadian Constitution Foundation, a Canadian legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting constitutional developments in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember that these videos are for your information purposes only. They are not legal advice. If you have your own legal question or problem, please consult your own lawyer. So I'll start by saying that this is not a case that we were involved in. It's just a case that I'm really interested in. And it is also a case that is likely heading to the Supreme Court of Canada. And if it does, in that case, we would consider intervening in that case at that level. Now let me tell you about the law that was at the heart of this case. The Impact Assessment Act, which many of its critics refer to as the No More Pipelines law, received royal assent in 2019, and it established what's called an Impact Assessment Agency. This allowed Ottawa to evaluate major projects like pipelines, interprovincial highways, mines, based on a wide range of environmental and social issues. The different types of projects that the law applies to can actually change because there's a list of what's called designated projects that the law applies to, and that list is prescribed by the federal cabinet. So the cabinet gets to decide. And one thing that's really important to know is that a lot of the projects that the law applies to are often wholly located within the borders of just one province. So those are the types of projects. Now, what about the impacts that are considered under the law? Well, those impacts are wide-ranging, with at least 20 different factors to be considered. And it's worth noting that assessing the impact of a project on climate change is a mandatory consideration. One of the most famous and widely reported on impacts that's considered under this law is there's a consideration of, I'm quoting here, the intersection of sex and gender with other identity factors. So whatever that is supposed to mean. And the law even considers things like cultural and heritage impacts. Now, calling this law the No More Pipelines law might sound hyperbolic, but the reality is that the law means it is extremely unlikely that new pipelines will be built in Canada. And sure, this law is not the only reason pipelines may not be built. Global oil markets can also impact demands for pipelines, but certainly this law makes it extremely unlikely that a new pipeline project would be approved. The law lengthens and complicates the regulatory process, it increases litigation risk, and it ultimately is a significant barrier to new investment in Canada. It creates a whole lot of uncertainty for investors. Now, the basis of the legal challenge was not really any of those things. The basis for the legal challenge was that the law is an intrusion by the federal government into provincial powers. Now, as you know, our Constitution divides federal and provincial powers, and the Alberta government challenged the law, calling it a Trojan horse that Ottawa could use to justify interference into areas of provincial jurisdiction. And Ontario and Saskatchewan both supported Alberta's challenge, as well as a number of interveners, including my friends at another organization called the Canadian Taxpayers Federation. And they have a video about their perspective on the case, which I'll link to. So what happened in the case? Well, the big news is Alberta won. The Alberta Court of Appeal ruled that the Federal Impact Assessment Act is unconstitutional. They wrote that the law would permanently alter the division of powers and forever place provincial governments in a chokehold controlled by the federal government, and they called the law a classic example of legislative creep. Now let's look a little closer at the decision. As a starting point, Our Constitution Act 1867 divides federal and provincial powers in sections 91 and 92. But the environment is not a head of power assigned to either level of government. Environmental issues may have some provincial aspects and they may have some federal aspects. But a project will only be subject to federal environmental oversight if it's connected in some way to a federal head of power. So because the environment is not listed as a head of power under our Constitution, the court needed to characterize what we call the pith and substance of the Impact Assessment Act of this law. And they did this by looking at its legal and practical effects. The Court of Appeal concluded that the main thrust of the law was the establishment of a federal impact assessment and regulatory regime that subjects all activities designated by the federal executive to an assessment of all their effects of federal oversight and approval. Characterized this way, the Alberta Court of Appeal found that the Impact Assessment Act intrudes fatally into provincial jurisdiction and the province's proprietary rights as owners of their public lands and natural resources. So the way the law worked was that a project would be automatically prohibited if it may cause effects within federal jurisdiction. Using this trigger, the federal government could claim oversight on the basis of, for example, that a project otherwise within provincial jurisdiction emits greenhouse gas emissions. The court rejected this self-defined effects within federal jurisdiction trigger and held that many of these effects were not linked or not sufficiently linked to a federal head of power. And citing the recent Supreme Court decision in the reference on the Greenhouse Gas Pollution Pricing Act, that was also kind of called commonly the federal carbon tax decision, the court held in this case that Parliament does not have jurisdiction over general regulation of greenhouse gas emissions. Now, after characterizing the Impact Assessment Act's pith and substance, the Court of Appeal considered whether the law could be classified under a federal head of power or even under what's called the peace, order, and good government power. The Court of Appeal ultimately concluded that it did not, and that it fell squarely within several heads of provincial power, including natural resources, the management of public lands, local public works and undertakings, as well as property and civil rights. Now, there are a few paragraphs of the Court of Appeal decision that are really an interesting read, especially paragraphs 26 to 28. So let's have a look at them. The Court of Appeal wrote about the Impact Assessment Act. Perhaps most troubling, this legislative scheme allows the federal government to pick winners and losers, not just in terms of individual that's within province, designated projects and individual categories thereof, but also in terms of individual provinces. Thus, the legislative scheme not only has a corrosive effect on the division of powers, it has an equally corrosive effect on the economic health and well-being of citizens of individual provinces. For those Canadians living in parts of the country with lesser populations and thus lesser political influence on the federal government, the economic and social consequences are especially devastating. True respect for federalism is the only defense against this kind of unrestrained federal power. Wow. But it doesn't end there. The Court of Appeal went on to say this is not an academic matter for Western Canada. The early history of Canada prior to 1930 singled out the prairie provinces for economic inequality compared to other provinces. It was only when ecological and economic disaster befell the prairie provinces that they were provided with the same ownership and control of public lands and natural resources as the founding provinces had retained on Confederation. So it's an important history that a lot of Western Canadians are familiar with, but which may be really eye-opening for a lot of people who live in other parts of the country. The Alberta Court of Appeal then went on to say the Impact Assessment Act raises an issue of fundamental fairness. Through this legislative scheme, Parliament has taken a wrecking ball to the constitutional rights of the citizens of Alberta and Saskatchewan and other provinces to have their 92A natural resources developed for their benefit. That's a reference to a part of the Constitution Act 1867. And in doing so, it has also taken a wrecking ball to something else. and that is the likelihood of capital investment in projects vital to the economy of individual provinces. Capital investment does not just happen, especially where the capital investment is measured in billions, not millions of dollars. And it particularly does not happen where, as under this legislative scheme, the investing rules are uncertain, unpredictable, unquantifiable, and unreliable. So these excerpts, as one might imagine, have attracted a lot of attention. Let me know in the comments below what you think of what the Alberta Court of Appeal said in those paragraphs, and generally what you think of the decision. So what comes next in this case? Well, this case is what is called a reference or advisory opinion. So that means the law is going to remain in force until it goes to the Supreme Court and then a decision comes from that court. The federal government has already said that they are going to appeal. And if they do, we're hoping to intervene in the case when it goes to the Supreme Court. And so we're currently working towards that. At the Canadian Constitution Foundation, we would be intervening to support the position of the government of Alberta and to uphold the decision that the Impact Assessment Act is unconstitutional and an intrusion into provincial jurisdiction. If you'd like to stay up to date about this case as it progresses, hit the subscribe button below and hit the notification bell, and that way, if I produce a new video about this case, you will get an alert right away. You can also sign up for our Freedom Updates at the ccf.ca/freedom updates. And if you sign up, you'll get notifications not just about our role in this case if it happens, but also about all of our other ongoing cases. For example, our lawsuit against the federal government for their illegal use of the Federal Emergencies Act, or our challenge in British Columbia to that province's vaccine passport policy. Okay, that's it for this update. Thanks for watching, and let's keep fighting for freedom in Canada.